Okay, great. Hi, everybody. My name is Brandie Janow, and welcome to a session with ADP List. We are all very happy to be here for our first session, and we hope to have many more called Know Your Design Rights. I'm a designer, and so I'm coming in with my design hat. And yeah, it's very important for designers to know their rights and to know how to take care of themselves and their designs. So yeah, we're here to empower you all and to have a conversation about these rights. So please, I'm going to go ahead and introduce everybody else. We have Elie Basbous, Zayd AlAthari, and Micheal Willis. And gentlemen, I'll let you all introduce yourselves.
Sure. Thank you, Brandie, and thank you for inviting us. It's a pleasure to be here. Again, my name is Zayd AlAthari. I'm a partner with the law firm of Norton Rose Fulbright. We're a global law firm, and I've been practicing intellectual property for over 20 years, and all aspects of it, helping inventors, helping creators, authors, etc. Basically, get value from their ideas, help them protect it and commercialize it.
I'll jump in. I'm Mike Willis. I'm an intellectual property lawyer based in the United States. I have a technical background in chemistry, so I help inventors often. But I'm also available to advise all sorts of creatives in their endeavors in sort of protecting their IP rights. I have more or less 20 years of experience in the IP field. I have some global experience. I was based in Saudi Arabia for 4 years in the 2013 to 2016. So luckily, IP is one of those legal frameworks that's very international. So happy to talk with you all today.
All right, I'll jump in. Hey, everyone. I'm Elie Basbous. I'm a business consultant working in a boutique firm based in Dubai. Today, I'm hoping to actually bring in some of my experience in the business world. I know it's a session about IP rights for designers. However, every designer also has to wear his business hat or her business hat. So I'll try to jump in and actually ask our experts, Micheal and Zayd, about their opinion about some ideas or notions that I would like to understand more about regarding IP. So thank you all for joining. Back to you, Brandie.
Okay, thank you all so much. Welcome everybody, and let's just get started. I'm gonna put a slideshow up just for visuals, and then we're gonna have some interaction in the chat. So keep an eye on your chat, please, everybody. And yeah, let's go. Zayd, if you would like to welcome everybody and kind of tell them a little bit about that session, that'd be great, since you are the expert.
Sure. Yeah, a good thing there's two of us, Micheal and I. So I'm happy to jump in and tell you guys about intellectual property. So really, the whole idea is, everyone here is a creator. They're investing time and money and effort. And the whole idea is you want to get recognition and value for that effort. Luckily, there are laws that you can take advantage of to protect it, right? And that's what intellectual property is about. And there's a variety of different types. There's copyright, design patent, trademarks, trade secrets, etc. And we're going to talk about that throughout our session today.
So our agenda is quick. We're just setting up the agenda now. We're having introductions and description of our learning objectives. We're going to go through the IP basics conversations. And then at the end, we're going to do a wrap-up review of the key takeaways for you all. And then we'll have a question and answer session at the end. So if you have any questions whatsoever, you can look at the bottom of this screen and it says Q&A. Drop all your questions there that are in regards to the topic at hand. And yeah, let's go. And so it's really important for designers to know their rights. The design industry deserves to be recognized and rewarded for their work. IP provides a framework for that recognition and compensation. Respect for IP can help designers in accomplishing their goals and their business needs. It's very important for designers and creatives to understand these rights.
And if I can just jump in,
Absolutely.
Part of the agenda today is so that people understand what their rights are, because that's going to be sort of a recurring issue for people who work in this field is, how can their rights be recognized? But, we also want to address the issue of the broader culture of, have in mind what your rights are, but also a respect for other people's rights. So, hopefully we'll be able to touch a little bit on some of the best practices in terms of what you expect from other people in respecting your rights, but also how you and your best practices can respect the rights of others, so that everyone, so we foster a culture of respect for IP, both in working with other people and with your own work.
Yeah, and that's exactly it, Mike. And the whole idea here is you want to, make sure you know your rights. You want to get your rights protected. You want others to respect your rights, and by that virtue, you want to respect the rights of others. Look, when it comes to design and certain industries and businesses, it's a small community, and you want to make sure that you're going to play fair in the marketplace, and you want others to do the same. And also, it's you're not an individual. There are going to be companies, there's going to be corporations, etc. And to know the rights of what your rights are or what your business's rights are and vice versa. Look, I think it's critical for success. And I think, what we're hoping to do is give you the tidbits that are needed here, at least to know your rights and, what you should know about, putting out your work and having it bring value and recognition. So I think, as we said, IP is basically their rights. Countries around the world got together and they said, look, let's put some laws on the books to help protect ideas. So you have intellectual property, which is basically intangible. You have real property, which is tangible. And these governments are doing this because they recognize the value of people investing time and effort to create and put themselves out there, right? And this is for technology as well. And if there are no rights protecting it, basically anyone can come and steal it. So the government said, fine, we'll put rights, we'll establish those rights. That way people are forthcoming with their creation and invention, and we'll give them a monopoly to help protect it. The very few places where you can have a monopoly is intellectual property. So that's kind of a nice thing. And again, the whole idea is when you're investing this time in developing something, you want to make sure to protect it, because if you don't, basically you're an R&D or a creation for other people, and you may not get the recognition or the reward or the value for that.
I like to tell a little anecdote about, why do we have intellectual property rights? And it goes back centuries. And what I was taught was that, you can actually look to the Venetian Republic 500 years ago to see sort of how we have the roots for how we have our intellectual property laws now. And what happened was they had a problem. The Black Death kept coming along and wiping out all of their artisans, and they were losing the ability to make some of their glassware and their metallurgy and their silversmithing and all that. So they came up with a system where they allowed the various guilds to write down their formulas for the glass that they were producing and things like that. And then they gave each of the guilds a monopoly if they would write it down and store it in the palace for safekeeping, so that next time the Black Death came through and killed everybody, they would have a record. And even today, if you go to Venice, in the lagoon around Venice, you have all these little islands that have their own technology that has 500 years of history behind it. So there's an island where they make lace. There's an island where they do glassware blowing. There's an island where they make certain swords and metallurgy. And it's all there from 500 years ago. More recently, when the US Constitution was being written, they included a provision for having a US Patent and Trademark Office because it was to promote advances in the arts and sciences. So IP has a long history, centuries of history. And where we are now is a lot of the modern laws sort of were adopted in the late 1800s. And so a lot of the sort of framework for the legal intellectual property laws is from a number of treaties, the Paris Convention, the Berne Convention, all these things that were done in the late 1800s. So unfortunately, what we have right now is laws that were written over 100 years ago as a framework, and we're trying to adapt modern ways of doing business to incorporate those laws. So if anybody likes to think about it, you can think about when the internet was first being invented in the 90s, they had to use telephone laws because they didn't know how to sort of handle the laws. So there are places where there's a mismatch between how you do business and how the IP laws handle it. But we can talk about that in more detail later. So those are just some anecdotes.
Yeah, and I think that's a good point. Like, just to emphasize, you know, in our world, and really the things that drive laws and technology and everything else is the business, right? So it's always important to, and this is where Elie's gonna, of course, jump in, and it's always good to focus on, hey, what's the business value? That's the first thing that anyone should think about, and then from there, think about, okay, what is the content I want to develop? How I'm going to develop it, and then after that, then you're okay. How am I going to protect it, right? And I'm protecting it to basically maximize my business plan.
Yes, that's true, Zayd, actually. So I believe every designer or every entrepreneur should always keep in mind or stay focused on the value of their work and how they can actually sustain it financially as well as commercially. So I think intellectual property is vital when it comes to actually protecting the value of your work. I just wanted to build on an idea that Micheal shared earlier. Regarding to the Venice anecdote, or like the so basically now we're in a world where actually everyone is trying to collaborate more, share their work, especially designers. They would like to collaborate on many ventures. So where do you think intellectual property plays a role in that, like in the sense of like, does it promote collaboration or does it actually refrain it, or what's your intake on that?
Well, I think there's, again, our laws are sort of a little bit outdated, and they may not necessarily be the best tool for the job of how to do collaboration. So the backup to that is to have sort of agreements, which would be more of a contract theory of how to do things. But I think there's an interplay between the protections provided by intellectual property and then sort of negotiating through contracts how one wants to do business with your collaborators and your partners. And unfortunately, it's a little bit unfortunate, but sometimes the IP hasn't caught up with the way we do business today.
I'm more optimistic about the IP than Micheal is. I think you know, the whole concept of intellectual property, and for example, patents, they expire in 20 years from filing. And the whole idea behind that is that you could keep something a trade secret or patent it, right? And if, you know, the governments were basically like, we don't want everyone to keep something a trade secret, but then, you know, there's no collaboration. It won't be available for society to build on. Yep. So they said, that's the patent system. It says, hey, disclose your idea and we'll give you a limited monopoly. It is 20 years, but then after the patent expires, then it's available for anyone to use, and then you build on it. And that's really the concept of technology. It's building on other stuff, but you can only do that if you know about it. And not all intellectual property is about exclusion, right? So patent gives you the right to exclude others from making, using, or selling. A trade secret, of course, exclude because you're keeping it a trade secret. But the idea is there's the recognition part of it, right? So I think that's important. So when it comes to trademarks and branding, and this is, it's a good segue slide to your question, that's protecting, names, symbols, etc. that is yours, right? Or is the company's, and that you build a reputation on it, right? You build a reputation, whether it's your design, your quality, whatever it is, and then people recognize that name or symbol and then will buy it, right? So in this case, trademarks and branding, it's about your rights, your recognition, your quality, your reputation.
And
the
the
idea is-
policy, the policy behind the trademarks and branding is that it's to allow people to invest the money in developing their product and making it a quality product. So if somebody spends a lot of money developing a quality product, they don't want other people to use that name for an inferior product. So it's meant to reward people for investing in developing quality products.
Let me ask you, gentlemen, two questions from a designer's viewpoint. Number one, we were talking about collaborations and IP earlier. So are you saying that it's important when we do things that we should sign maybe NDAs, sign contracts, sign agreements? Is these really something that is important that designers should be doing?
Yeah, so you know, we will get to the trade secret and confidentiality part of it. But the idea is you know, these are lawyer responses, maybe. So look, if you if you have something that that you think is extremely valuable, and there's not other ways to protect it, right? So you don't have a patent. You may not have you may have trademarks and branding, but that's more on your name. So you want to protect it before you disclose it and collaborate with others. The whole idea is to disclose and collaborate with others, right? And the collaboration can be with partners or suppliers or vendors, right, or customers. So at some point there's going to be a disclosure part of it. The question is one, and am I at the right place for disclosing it without having someone take it without my knowledge? So
one of the advantages of having some of that paperwork in place, Brandie, is that I would say the advantage of putting the paperwork in place is sometimes it can help refine the thought process, right? Putting the effort into sort of making it clear on paper in a written form can help you say, oh, this is actually what I was thinking, and it can avoid misunderstandings. So there is a value to having the formal paperwork in place when you're having discussions with outsiders, and it is more work, but sometimes it helps you refine your thought processes, and it makes sure you and the other side sort of are seeing eye to eye.
Great,
Yeah.
thank you. And then my second question, my second question is about these symbols, these little symbols. We see them everywhere. We see them on the bottom of websites. Zayd knows that I always ask him everything. I designed a little book about a month ago, and I sent Zayd a message. Zayd, what can I do to make sure that this is protected so nobody copies me? Because I wrote the content, I designed everything, so it was important. And he told me what to do, and I did everything he said, all of these lists here. So if I do that without filing paperwork or without paying anything, does this protect me as a designer just by doing these simple things?
The answer again is maybe. So for the trademarks, and you'll see there are two symbols in there. There's the R with the circle around it, and then the TM or SM. So TM is trademark, SM is service mark. So the R just means you actually filed a trademark application. So in trademarks, there's common law, which means you do things, and when you go to court, it's recognized as you have a trademark. And then there's also you can file a trademark application with a trademark office, right? It's jurisdiction specific, and they will examine it and see if no one else is using it and it's unique. They'll grant you a trademark. So that gives you the R. So you'll have a logo, a name, a symbol, whatever it is. You want to identify it that it is a trademark, right? And this is one of the ways of establishing trademarks is by identifying it and using it in a way to describe your products, right? So this is, Brandie was the trademark. This is, Brandie art, Brandie design. And you want to use the TM for trademarks. You want to use the SM for service marks. And if you have a registered trademark application, you want to use the R. You want to this basically gives people notice and again acknowledges that there's a value in your product and services, and it's attributable to your name.
So if you want to, so the short answer is if you want to use the TM, you can use that on your branding. If you want to use the R with the circle, there's paperwork involved. You have to actually submit that for review and approval through your local government.
Yeah, and there's a cost, of course, associated with trademark application filings. It can get pricey, and it is jurisdiction specific, so it depends on how many countries you file in. With the TM, it's less because it's just a matter of making sure you're identifying it with the TM and you're using it in a way that it's clear it's a trademark without the costly filings.
Right. So this is just some background information. Like I said, the Paris Convention is one of those treaties that was from around the late 1800s. And trademarks have been around for a while, and the recognition that companies want to have a brand that they can identify themselves with.
And Micheal, why do you think that countries haven't updated these systems? What's the reasoning?
Well, I think if it's not broken, don't fix it. But I think as we get into areas where the global outreach of the internet has really changed a lot of these things. So I expect within the next 10 years, there will be updates in a sort of a major way to sort of appreciate the sort of international scope of and access that everyone has these days that they just didn't have before.
Yeah, and again, look, the technology and creativity is moving a lot faster and exponentially in society. And the business, again, this is all like this happens, the business jump in, the business starts driving it, and then from the business creates disputes, and then the courts get involved, and then laws start changing, right? So that's why the laws and the courts are behind everything else, because the technology is kind of driving this new innovation. You're talking about, now you have NFTs, you have the metaverse. These are creating concepts that weren't addressed before by laws or courts, and there's a catch-up that's associated with it.
Everybody, all of the participants, we're going to drop a poll, and we would love to know what type of designer you are in the chat. So we would appreciate if you answered.
And perhaps we can talk a little bit about copyright. Oh, trade secrets. We can do this real quick. The issue with trade secrets is there's sometimes when people don't want their information disclosed publicly. So the difference between trade secrets and some of the other types of intellectual property is that trade secrets are not formally registered anywhere. You have a trade secret by keeping it secret. It's that simple. And there's still times when you want to talk to other people about your secrets, your trade secrets. And Brandie, you mentioned a non-disclosure agreement or a confidentiality agreement. You would generally,
so when it's Saudi, we have to sign an NDA for even breathing, I feel like.
Right. So normally you would agree in advance with somebody that you're going to talk to that you're going to keep something just between the two parties. And that's what a non-disclosure agreement or a confidentiality agreement is meant to accomplish. But it's a way to let you talk to certain people about things without disclosing them to the public.
And then what kind of things can happen to people? Like if they break these contracts or these agreements, these NDAs, like what can
they're not going to jail. It's simply money. Okay. There has to be an economic, what's that, Zayd?
I beg to differ. So
they want to send people to jail.
So if actually if you're an employee at a company and you're exposed to trade secrets, and it's very clear that these are trade secrets, like for example the Coca-Cola formula, if you go to another company and misappropriate those trade secrets, it's financial damages as well as criminal sanctions as well. So you can go to jail.
That would be a theft, sort of looking at it like a theft yeah.
So look, I think the idea behind trade secrets and confidentiality, this is a very low-cost way for you to protect your ideas, your inventions, your designs, etc. But you have to take steps, right? And this is especially like in the food industry and recipes and formulas and stuff like that. This is huge. And the whole idea would be you have to take steps to keep it a trade secret. Right? So one is you keep it confidential. You mark things trade secret, confidential, so it's clear. You don't disclose it to others. If you have employees, you make sure your employees know about it. You keep it in secure databases, right? So you don't want to get hacked and someone's gonna take all your stuff. You want to make sure that that it's very secure. In your office, it's locked up in a drawer. If you're a company, you have policies, procedures on it that to do that. And then the whole idea behind the NDA, there's different ways to approach it. Now, you want to collaborate, right? You want people to know about your idea so they can come to you and buy it. But you want to make sure they don't also take it. So you can. It's fine that you talk to someone without an NDA, but do it in a way, kind of a responsible way. Like if there are ways to kind of put the information in pieces where you don't have to disclose everything, just disclose on a need-to-know basis only that. And then if your true trade secret it needs to be disclosed, then you can consider after preliminary discussions to say, okay, now I think it's reasonable to sign an NDA.
Zayd, I have a question. So actually, I've always thought about it. So let's say someone, I signed an NDA with a company or an individual. But let's say I actually had the same idea or the same business idea or the same design idea. How does that does it make it a conflict of interest? Should I disclose it? How can I act about it? And will it be their idea or mine, or their design or mine? Let's say if they're intersecting. We can notice it maybe in fields where people, where high competition fields, where actually people are creating a lot of similar designs or similar products within the same, let's say, category or range. So who has the, let's say, the right here? Is it like the one who initiated the NDA, or like how does it happen?
Yeah. So look, this is the tricky part about trade secrets, and this is what we call contamination, right? So you both come in, you want to talk, you sign a confidentiality agreement, meaning whatever I tell you, you keep confidential, and whatever you tell me, I keep confidential. So whatever you hear from them, you got to keep it confidential. Now, if you hear the same thing, you have a problem, right?
Yeah.
But the whole idea behind it is and this is why we always advise designers or scientists or whoever to keep lab notebooks and sketch notebooks, put dates on them, record basically the development of your ideas. It's a good way to remember your ideas. And by having the dates in there, you're actually creating a record, because what's going to happen is both of you are going to say, oh, I came up with it. You're going to go to court. You may have a dispute. You have evidence to show, hey, by the way, before I signed this NDA and I spoke with you, I have a record. It's fine that both of you come up with the idea at the same time, right? And that happens, and sometimes this is the issue with it when you decide to keep something a trade secret. Let's say it's on the technical part or a design, and then someone else comes up with it independently and files a patent application. They actually will get granted the patent. And if you haven't been using that in certain areas, they can stop you from using it. But with both of you having
as a practical matter, what some people will do if the overlap in what they want to discuss is too close, they simply won't have that confidential conversation because it's too close. That's one practical approach. The other approach is to say if it's done independently, both parties agree it's okay, but usually there's some paperwork involved in sort of showing that. So those are the best way to protect yourself is to keep good records.
And also, I just want to state everybody that while a lot of these questions in this talk is very open-ended, every country is very different. So you really have to dig into your country that you're working in to find out the details of what is legal and your own rights.
Yep.
Yeah.
So that's probably enough on trade secrets, I'm thinking. Now we're getting into the area of design, which is probably of most interest to the audience, I hope. So when it comes to protecting designs, there is a system for having design patents in most countries. And there's sort of distinguishing between a design and a utility patent. A utility patent would be for something that's functional. So for example, a pharmaceutical drug. A design patent would be for something that's ornamental. And as a practical matter, how that's done is one would draw a picture of the ornamental design and then submit that picture to the local patent office for review. And the limits of the protection that you would have with a design patent are for the ornamental aspect of it, not for the functional aspect. So if you have a particular design that goes on a bottle, it would be for that design on the bottle, not the bottle itself. So there is a system for protecting designs. The way to do it, though, is it does require some paperwork. You would have to hire somebody to prepare the application and submit it to the local patent office. So you'd have to decide, is there a return on investment? If that's going to cost you between, yeah, Zayd.
Yeah, and you know, the cost is filing fees and again, it's jurisdiction specific.
Yeah.
So if you want protection in the US, you have to file a patent in the US. If you want it in Europe, otherwise you give up that right. And there are filing fees and there are lawyer fees. And there's usually an examination period, so there's a back and forth between the lawyer and of course you and the patent office. And you know, for utility patents, they tend to be a lot more expensive because those give you a broader protection, again, because it's on the more on the technical side, and there's a functional aspect to it as well. And those tend to be, you know, last for 20 years, and can get quite expensive.
So yeah, I was telling the gentleman that most of us, this is a holdback for designers and creatives as a whole, is because we're the starving artist, and we automatically, when we hear about trademarks and patents and copyrights and all of these kinds of things, we're like, whoa, we can't afford these things. And so we automatically think that we can't protect ourselves. Me as a designer, I've had many things stolen, and it continues to be stolen because I just always think that, hey, I can't afford to fight this. This is a big company. And this is sad that a lot of the most creative people, they feel this way. So Zayd, I think that you were saying earlier that maybe if you have a really big ideal that you think will really make you money, or that can be something amazing, that maybe this is the kind of thing that you should invest in instead of all the little things for people like me, right?
Yeah, no, absolutely. I think again, going back to the business and the value, you always want to have this balancing act, right? Because you're going to spend money, and it's an investment, and the whole idea is, what is my return on that investment, right? So if this is going to be a blockbuster idea, then it's worth that money, right? You're going to spend, you know, thousands on it, but it's going to bring back millions.
Unfortunately, the ego of a designer is very big, and we think all of our designs are going to be blockbuster hits.
Everything is $1 million idea. Look, and I think that, well, then you kind of put it in action. So one of the things you can do, especially if you have blockbuster ideas, is you don't need to do this yourself, right? So this is where you would approach bigger players and say, hey, I have a blockbuster idea. Let's sign a trade secret or a confidentiality agreement. We'll talk about it. If you like it, then you invest, you take care of the IP. I'll manage the IP, you pay for it, and I give you, you know, a stake in the future business or royalties or licensing or whatever it might be. that you negotiate with the others. So again, it's all a balancing act. So figure out what you think are the most valuable, right? And then prioritize how you protect them. And you use, and I think we're still going to talk about copyrights, because those are, that's another great one that we have some tidbits that can help you. But you use your trade, your trademarks, you use your brand, you use maybe design patents, you use the confidentiality, you use a copyright, you use a variety of different things to try to protect it as much as possible. It's all about trying to maximize the value and mitigate the risk, right? The risk of it being stolen, and there's also the risk of you being sued by others. So the balancing act should include all those factors.
Oh yeah,
sorry, please go
yeah,
ahead.
Go ahead. I was just going to add, so in addition to design patents for being a way for designers to protect their designs, there is something called trade dress, which is sort of a hybrid between trademark and design patents, and it's a way of for designers to sort of have a non-functional portion of a design and registering that with a local office. And you would have to seek local counsel to see how to do that. But again, it's if you're going to go into having a shoe that has your design on the shoe, it's really the shoe with that design on it that's being protected as part of the trade dress.
Jens, I have a question. So in a design life cycle in general, whether it is software design, where it is a product design, service design, in general, like when do we start thinking about having a patent? Do we start thinking about it at the beginning of the design cycle? Do we wait till we finish everything and then we initiate it? And I think it will also impact how we design the product. So maybe we would like to design a different component for it to be unique, or for it to be able, or like to be eligible to be patent. So basically, to sum it up, when do we start thinking about filing a patent?
The patent process is by design very early it basically has to be at the start of the process.
Yeah, so I think that, I mean, it's always a balancing act. So you need to have developed enough to have a patent application. You need to have developed enough to describe it in the patent application, right? And it really, so there are claims in the patent application which define your invention, and those are what you're going to get the grant on, and those are what you're going to basically sue people on if they're infringing your patent. So those have to be, one, complete, and also they have to be broad enough that you can make sure you're protecting your ideas completely. So that's more on a technical perspective. The other issue on timing is when you file a patent application, it has to be new, which means that anything that existed before it can be used against it, which means you want to do it as quickly as possible before someone else files on it. And also you want to do it before you make any disclosures, because if you publish anything, if you disclose it, that act will be prior art against your own patent. So that's, so sometimes maybe you have, an exhibition coming up and you want to publish and you want to mention it, make sure you file your patent before that. Because if you do it after, you basically closed off your right.
And just to remind you, the entire reason for the patent system is to get people to disclose things and give them some protection for disclosing it. If you've already disclosed it prior to filing your patent application, the incentive, the reward is no longer needed because you've already disclosed it, and so you won't get a patent.
Makes sense.
So the patent is supposed to reward you for disclosing it.
So I have a question. So you mentioned that it has to be unique. So is there a way for a designer, or like a central registry for a designer or an individual, to actually go and look for like similar designs that are categorized, or like to check if actually someone else actually filed a patent, or it has to be like you fill the patent and then you see the response of the entity or the legal entity where you've filed it. So how does it work actually? It might
So
seem like straightforward to you, but like to us, it's
not at all, not at all. So that's the disclosure part. So once you file an application, all applications publish 18 months after it's filed. So and they're published by the patent office where you file it. So each patent, the majority, I should say each patent, the majority of global patent office, like the US, like Europe, etc., you have full access to their databases. They have great searching ability, and you can go on. Well, and this is for trademarks as well. You can go and you search what's already out there, and that's highly recommended by them. So that's a very good comment, both on the trademarks as well as the patent. Make sure you go out before filing anything or doing anything. Search what's already out there. Because if it's already out there, one, it's already being used by someone, which is then prevents you from getting a trademark or a patent, but also then they can, if you start using it without the permission of those entities, they can sue you and stop you. So this is what we usually call freedom to operate. You want to conduct the freedom to operate exercise, meaning make sure there's no other IP out there that can stop you from doing it, and that's especially the case with trademarks and patents.
So
just to
yeah, and just to throw in, most of the patent offices and trademark offices are designed to be accessible to the public. If you've got 8 hours to do a search, and you can, everyone at this point is familiar with doing like Google searching, and it's a little bit like that. The professional could do it in 10 minutes, where it might take you 8 hours just to be certain you've looked everywhere. So if you've got the time, you can do it yourself. If you want to outsource that sort of thing and have a little bit more certainty, you can hire a professional to do that search for you.
All right, thank you for the clarification. I think
there's also Google Patents that's available and free for everyone. So Google thinks of everything.
Oh, I didn't even know there was Google Patents. There's so much information, Micheal and Zayd. I think you need to write a book for us. It's very overwhelming. I told them that creatives, it's hard for us to take on this information, but it's important because I feel like we get bullied a lot.
So, just to sort of highlight, so the main types of intellectual property, and these are sort of legacy things from 100 years ago, is the patent system, the trademark system. There's protection for secrets, trade secrets, and confidentiality, and then as well as copyrights. So I don't know, did we miss copyright?
Yeah, so I think we missed we may have maybe
we talked right over copyrights.
which is one of the most important ones, so we definitely want to hit that one up. Maybe it's not
well, we can do
go ahead and talk about copyrights, please.
The short version is copyrights are meant to sort of protect the authors and musicians and people have fixed media photographers, and it's meant to protect those types, not the technical aspects of a patent. And so the nice thing about copyright protection is it is automatic, in the sense of if you are a producer of copyright material, you can add the little C with the circle around it, and it's automatic protection. To sort of additionally protect yourself, you can submit it. For example, in the US, you can submit it to the Library of Congress or various things, but there is
Micheal, when you say automatic protection, what do you mean?
What I mean is, by saying that this is your copyright material, you are telling the public when they see that they need to talk to you. They are supposed to get your permission before they copy paste.
Yeah.
Right.
So basically, like a copyright is any idea that's expressed in tangible form, right? So if it's written down, typed out, PowerPoint presentation, Word document, Instagram, anytime an idea is put into tangible form, there is an automatic copyright associated with it. You put it, you record it, you write it, boom, copyright. You have like it's instantaneous. It exists.
So as
You
an
don't even need to.
example, yeah, as an
you
example,
don't-
if you write a book, you copyright the book and nobody can copy paste and produce that book. Now, if you are a publisher and you're publishing the works of Shakespeare, the actual works of Shakespeare are hundreds of years old. There's no copyright for that. But the way in which you assemble the material, say the footnotes that you put in, the sort of your way of publishing Shakespeare's work can be copyrightable, but only to the extent that somebody can't take a picture of the page that you've produced and then copy that on a copy machine. They can independently compile the works of Shakespeare themselves, as long as it's not a photocopy of your work. So that's sort of the distinction between something that's absolutely new in terms of a new book and something that is around, such as the works of Shakespeare, but you've put it in a tangible form that's protectable, right?
Yeah. And look, again, as soon as you create a PowerPoint presentation or a design or anything, you put it on paper. You don't need to do anything else. You have copyright. You have copyright protection. Now, what you want to do is always, take extra steps to make sure that it's protected. So when you do that, any documents you have or anything that you post, put your name on it, put a copyright, to say copyright, name, year, or the C with a circle. Identify those, because that makes your material stronger, and it identifies it and gives people notice that it's yours. Again, this is just things you can do. It's not, it'll take a couple of seconds to do it. It's not that much time, but it's a good way to establish your copyright and to give people notice that it's yours. Now, once you have that copyright, no one else can copy it unless they have your permission. Now, if someone does copy it, then what you can do is go and register that copyright with a copyright office, right? And it's jurisdiction specific. And the reason why you want to do that is because then the copyright office gives you basically a documentation certification that, hey, this is your copyright, and you can go after people in court. You can go to customs. There's some offices and governments that have kind of a complaint system. So for example, the Saudi IP authority you can go on their website, whether it's trademarks, copyrights, or whatever, and submit a complaint that someone's infringing your ideas, and they'll do an investigation. And if they determine that it's the right, they are infringing it, they'll go after those people. This is a good way to go after people.
The first thing you might do, and it's to sort of assuming the other person is a good actor, is you can write them a letter. It's called a cease and desist letter, and kindly ask them not to use your copyrighted materials. So you let them know you see what they're doing, and that you want them to stop copying your copyright material. Now, you can do that yourself, or you can, if it comes from the letterhead of a law firm, it looks more official, and sometimes people will take that more seriously. But that is the sort of the lowest energy, lowest cost thing to do, is just to simply write a letter. And a lot of people are actually good actors, and once they realize that they've copied somebody else's work without permission, they will take it down.
And I will say, it's very bad taste across the board, not just for designers to copy people's words, to take the images, to use anything that doesn't belong to you without requesting it. It's not good taste, and you should never do this.
Right.
Yeah, look, and I'll be a defense attorney. I'll put the defense attorney hat. Look, the issue with copyright is it's very specific. Right? It's you put it in tangible form. It is what you put in tangible form. People can change things, right? And get out of the infringing your copyright. They can, if they make enough changes, then they basically get out of the copyright, and then they have their own copyright. So this is one of the issues with copyright is, although it's a very easy one, it's instantaneous. It's low cost. However, it doesn't give you the broadest protection, right? And of course, the ones that give you the broadest protection are the most expensive.
Yep. Yeah, but as a first step, lots of people want to consider themselves to be good actors, and if you just let them know they're violating a copyright, then they will oftentimes take that down.
That's true. Usually I love to use the term, I'm going to talk to my lawyer, and it scares everybody. Just FYI, I use this constantly. Thankfully, I'm friends with many lawyers, so it can really happen. So my advice is to have friends that are lawyers.
But the truth is, there may be some people who are in the industry what we call judgment proof. So, if there's a 12-year-old child who's seeing something on social media and copy pasting it and posting it somewhere else widely, and somehow that goes viral, with no money being involved and with this just being a child who's sort of acting irresponsibly, you may not, be able to shut that down completely. So they're just judgment proof. Like, they don't have any money, you can't sue them. And that's just the reality of the way technology is now.
Gentlemen, thank you all so much. We have a lot of questions and we need to get to it. I want to respect everybody's times, but if you guys just want to do a quick takeaway and wrap up of the session, and then we'll get to the answers, to the questions and answers.
Yes. So for me, just again, looking at your, what you want to do, how you want to gain value, how you want to get the recognition, and then think about the variety of different protections that you can put in place. Again, try to balance it out. A lot of these things can be done in an inexpensive way and an efficient way. And then the things that will be more costly, then your business case is going to help you out. If this is going to create a lot of value, then it's worth that investment.
And again, a little bit to that, I like to use musical analogies. So if you're a musician and you make your money by touring and going and playing in live at various venues, you don't care so much about people who do bootlegs, because you're making your money from going individually to play your music at each of the venues. If you're a recording artist and you show up once to make a recording, it's very important to you if people are doing bootlegs, because that cuts into your bottom line. So keep in mind what your business model is and how you're planning to make money off of your designs.
Okay, thank you all. Elie, I'm going to let you take over the question and answer session. We have a lot of questions for you all.
Sure. Thank you, Brandie. So the first question is that, can design interactions patterns, so basically, can design patterns be patented? Do we need more clarification, gents, or is the question clear?
I think pattern like this. I'm presuming like a specific pattern, right? Like
let's say the Nike swoosh.
Yes,
is
for
that
example.
The Nike swoosh? Okay. The patent system rewards newness, and so the very first time the Nike swoosh is used, yes. But after that, it would get harder and harder to try and get a patent for the Nike swoosh in terms of where it goes and what you do with it and what the design is. So the patent system has its limitations, and one of the things is it's very strict about newness. So yes, the first time, afterwards, maybe not so much.
Well, I mean, that makes sense, because then it's prior art. So you can only get it once.
Yeah, that's the one thing about patents, is it's a one-time thing.
Makes sense. Another interesting question in the Q&A is that, if a patent is filed in a certain country, does this patent have a jurisdiction in other countries elsewhere in the world?
Nope. Simple answer, no.
Yeah. So that's the thing. Like, they give you kind of a time frame, file these patents in some countries, otherwise you give it up. I mean, there's some nuances where, for example, if you have if you have like a product and a process patent, let's say in the US, and then you didn't file in China, if someone manufactures the product in China, they're not infringing any patents because there aren't any there. However, if they are trying to sell those products into the US, then you can stop them. So then the patent will stop those products coming in from China.
Yeah. There is a pattern. There is a system for how you would do lots of applications in different countries all at the same time. As a practical matter, the pharmaceutical industry does that because it's so easy to move drugs, pharmaceuticals from one country to another. But for the most part, a lot of other industries do not seek patent protection globally. It's just too expensive.
Yeah, and because brand name drugs are making millions in profits a day,
Yeah,
right?
so-
Just to have that patent. So they will file in a lot of different places to make sure that every single day is extended because they're making millions.
So
But-
basically, if someone wants to protect their IP, they should file it in multiple jurisdictions. So to cover
And there is
the-
a system to do that. It's just it is probably prohibitively expensive for most
Yeah.
So
industries.
probably to protect ourselves, we have to be billionaires.
Yeah. Well, no.
Well,
You pick your market. You pick where's your market going to be, right? If all your sales and everything is in the U.S., then that's you pick the one patent, make sure it's in the U.S., and that's it.
Absolutely.
Yeah.
So as you all know, I have a business, Smug, and in my business, it's very niche for Saudi Arabia. So for me, it would only make sense to do this in Saudi Arabia. Completely get it. Thank you so much.
All right, so we actually received multiple questions. I'll try to rephrase it in a simple way. So whenever we have an agency, a designer, and a client who owns the design, and basically another question related to it is basically if an employee didn't sign a specific clause in a contract with his company, who would own the design as well whenever they're working or a designer is working on a specific design?
And I want to pop in really quick because I actually got a question like this from a design student here in Saudi Arabia, and she had the same question that's related to this. She wanted to know, whenever I have my designs in the university, is it mine or is the school's? So I think a lot of people are very confused about these rights.
I'll take the school one. So I studied chemistry, and as an undergraduate, I didn't invent anything with regard to chemistry, but if I had, I believe the general thing is that when you're just a student and you're paying tuition, your work is yours. Now, as a graduate student, when I was getting my PhD in chemistry, I was actually, in a sense, an employee of the university because I was paid a research associate position. And the graduate students doing research did have an obligation to assign their inventions to the university. So anything I invented as a chemist when I was in my PhD program belonged to the university. So there can be some distinctions. I think there can be some local variations, but if you're, as a student, if you're getting paid by the school, you're probably considered an employee and then it would belong to the university. If you're just a flat out student and you're paying tuition, chances are what you do is yours. In the other context, with regard to agencies and employment, if you're an employee, the general rule is that what you create as an employee belongs to your employer. Generally, you have the right to be recognized as the artist or the designer mostly, but if you're actually an employee, it would belong to your employer. If you're a contractor and you have a contract, it would depend on what the contract says.
Yeah, I think again, depending on the jurisdiction, I think the agreement will dictate everything. I think as a university student, as an employee, as a contractor, agency, whichever, make sure this is I guess a session for another day. We'll talk about agreements and what are the key provisions from it.
I told you that was the most popular with the designers.
Yeah. No, I mean, look, in our business, that is absolutely the most important thing. And for me, that where I work for clients, that the agreements are key, and we scrutinize every single provision and we fight over every single provision. And I think, in my opinion, generally, whoever creates or invents, they're the owner. You automatically own it, right? Unless you assign it or license certain rights to others. And those assignments and license are done by agreement. So if the agreement doesn't dictate you have an obligation to assign, or or you do assign, that's it. You keep your own invention. So scrutinize those agreements, look into them, And if someone pushes back and says, hey, by the way, no, you have to give me that, it'd be like, okay, show me the law or show me the agreement that I signed where I said I would give you the roads. Otherwise, I'm the owner.
Okay, makes sense. Makes sense. So there's actually an interesting question. Actually, we discussed it while we were preparing for the session. And it's interesting that we had almost the exact question. So basically the question is, when we're working in agile practices or in fast-paced, let's say a product or like a service, anything design life cycles, how can we have a quick way to document or like protect our ideas while they keep changing? So like the participant was asking, do we like submit everything in writing? Do we take screenshots? Like what would be sufficient for it to hold as an evidence that this was created by us?
So I guess is it the keeping a trail of evidence or actually protecting the right?
So it's a mix. The question is a mix. So I think people are confused, as I was confused as well. So what should we do to protect the design? Should we wait till the end? It's an agile, fast-paced, let's say, the design life cycle. So what should we do? Should we wait till the end to protect it, or should we start taking measures like screenshots, documentation, or whatnot?
It depends how much money you have, right? So, like the number one filer in the world of patents is IBM, right? Because I mean, there's just any little thing they do. The patents are almost exactly the same, but any little change they make, they just churn out. Now, IBM has a lot of money, so they have, they have the ability to do that. So again, it all depends on, and again, it's industry specific. Documenting it is one thing, right? If it's fast paced, you're going to be like the actual development of it is fast, and there are a lot of changes. I would say once you realize or appreciate that this is the commercial embodiment, this is where I'm going to go live. That's really, you got to do it that on that one, right? And the closer you get to that, the more you kind of have to make a gut decision. Hey, this is the time to pull the trigger. So the documentation, I guess, if you're working in the digital, to a certain degree, it's easy to keep track of that. Otherwise, you're kind of writing down things here and there to create the record. But the record is only if you get into dispute with others, right? And that comes up with the trade secret. If you're planning to file, usually the first to file is the one that's gonna basically win it.
But it does have to be in complete enough of form to be, basically the final product. Like draft forms that are pretty distant from the version that goes live is not that helpful.
All right. There's actually, I think we're stepping a little bit over time. However, there's an important question. I think we can wrap up with it. And the question is about, are there any pro bono or non-profit organization associations where people can get legal advice regarding their intellectual property? And I'm going to extend the question to maybe also include in the answer, if possible, some references or some places, online websites where people can actually get educated, or like forums maybe where they can exchange ideas about it. So, gents, I think you might have this answer.
Yes, a quick one would be university, universities, especially the top IP universities have IP clinics where you're basically, it's students doing it with a professor, get credit for it and stuff. So these clinics are usually would help out people in need.
The various national patent offices oftentimes have a lot of resources available within the patent or trademark office, which can help guide like the sort of what they call the garage inventor or the solo inventor. When it comes to patents, those are very much a business tool, and they're all about kind of the economic aspect of it. And so there's not that much pro bono work with patents because they are business tools, and it's for corporations a lot of times. So those corporations don't need the pro bono support. But for artists and musicians, there can be resources. I haven't heard offhand of any design organizations that give pro bono advice to designers, but as a resource, I think sometimes your national patent office or patent and trademark office may have resources, and certainly they post a lot of information.
If I know Brandie, she's going to create a pro bono designer
advocacy group. Yeah.
Thanks so much. I have to stop doing things. My brain's like. Anyway, first of all, I just want to thank all of the panelists for your time. It's so kind of you all. They have put in so much time. I know these sessions look like they're quick and easy. We come in for an hour and talk, but I've been bombarding them with emails. We've had sessions and talks and meetings. They really put in a lot of their time and work to be here for everybody. So thank you each so much. We're all very appreciative of your time and your knowledge. And thank you so much to everybody that signed up and tuned in. I'll make sure to send you the PDF of the presentation and the link to the Zoom itself. Thank you so much, ADP List, for having this amazing platform for everybody. Thank you to Felix for believing in the design industry. And I am very proud to be your design ambassador in Saudi Arabia. And yeah, just thank you, everybody. I really appreciate everybody that came and spend an hour of your life with me. And I really
Thanks,
hope
Brandie.
that you found some empowerment and knowledge from this group.
Thank you.
Thank you,
Thanks
Brandie,
thank you
for
very much,
hosting.
Elie. Thank you, Brandie. Thank you, Mike. Thanks, everybody.
Thank you, everyone. Thank you
Thank
for
you.
listening to us. Ciao. Have a nice evening.
Bye, y'all.
Bye.